I'm not getting any younger, he tells me. You want to know why my 70-year-old client called me to express frustration and tell me, listen, I'm not getting any younger? Come join me for a walk through the neighborhood as I share with you exactly why he was calling all frustrated about the fact that his case was taking so long. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. This was a medical malpractice case. And now, one day my client calls me. The case has been going on for 3 long years now. And he calls me and says, listen, I recently had my 70th birthday. I am not getting any younger. When is this case going to finish? And now, rather than give him a quick, snippy answer, I had to give him a very detailed explanation about why his case was taking so long. When he first started this case, he expected and he hoped and he anticipated that it would be so clear-cut that the defense would throw their hands up, roll over and say, okay, Mr. Jones, you're absolutely right. How much do you need to settle this case? That would have been the ideal, but that's not reality. And the reality is that at the very beginning of the case, the defense knew nothing. They knew none of the details about what actually happened to my client. After I had gotten confirmation from a medical expert who told me that my client had a valid and meritorious case, now, not only did we have to start the lawsuit, but a few months later, after all of the people that he had sued had now answered those allegations, and by the way, they denied all of them, now I had to go ahead and prepare a document called a Bill of Particulars, which itemized each and every allegation against each and every person that we were suing in this case. That gave them some additional information, but they still didn't know many more details. So, one of the things that we had to do is go forward with depositions, which, if you don't know, it's a question and answer session where the opposing lawyer has an opportunity to question you, the injured patient, the injured plaintiff. In pre-COVID times, it was often done, and in fact, it was always done in your attorney's conference room. After COVID, many times it's done on a Zoom video call. And the answers that you give in response to those questions represent your sworn testimony. And even though it's being done somewhat informally on a Zoom video call, the answers that you give carry the same exact weight as if you are testifying in court in front of a judge and in front of a jury. So now, we had to go through that entire process where my client was questioned for many, many hours about all the details surrounding his case. In his own words, he had to explain what happened to him. In his own words, he had to explain to the defense attorneys exactly what problems and limitations and damages he suffered as a result of the wrongdoing that occurred. Now, you might be saying, wait a second, shouldn't they have enough information at that point to go ahead and try and negotiate and settle this case if it's so clear-cut? The answer is hopefully. But in most instances, the defense is going to turn around and say, listen, we're not ready to begin discussing the possibility of discussing settlement. However, we want to go ahead and allow you to question the doctors who are involved in this case. And once that happens, we will reassess and reevaluate whether or not this case is worthy of actually trying to negotiate. Well, they know from the defense's standpoint, after talking to the doctors and nurses and hospital staff, from their own version of exactly what happened. Plaintiff, the injured patient, may have a different version of some of the events that occurred. They want to be able to show that there are obvious differences so that they can now use that as leverage when they try and negotiate, if they're going to negotiate. So now they allow their doctors to go ahead and be questioned, which, by the way, they are required to produce their doctors and other witnesses that we request, and they have to do that. But in terms of settlement discussions about when this could happen, they often will want us to go ahead and question them to establish from their clients exactly what their position is. And now my client said, okay, now you've done the following doctor's depositions. Why don't they have a better understanding of exactly what happened, and why aren't they starting to negotiate? And the answer is, they may want additional information. They may want more details or updated medical records from you. They may want to learn what additional problems you have now since the time that you actually testified a year or two earlier, so that they can now reevaluate and reassess whether or not, number one, they have exposure, meaning that there is liability, that we will be able to show that we are slightly more likely right than wrong, that what we are claiming is true. And then we also have to be able to show that that wrongdoing was a cause of your injuries. And again, all of those things must be confirmed by our medical expert or experts. So all of these things have to be done, and the defense wants to do the same exact evaluation. And they will have various medical experts review all of the records at the conclusion of what we call discovery. After all depositions are done, after all documents have been exchanged, now they will send off all of those records to one of their experts and say, okay, tell us what you think. If after talking to their expert, they may come to the conclusion that there is no way to realistically defend this case, in that instance, now they may go ahead and start settlement discussions. However, their expert may come back and say, listen, we believe the case is fully defensible, in which case they are not going to enter into settlement negotiations, and they will likely come back and say, listen, we're not settling this case. We have to go to trial to resolve this. In which case you turn around, and my client turned around and said, I don't understand. Our expert said this was so clear cut, this case should have been over within months after starting it. Then he said it should have been over after my deposition. Then he called me frustrated saying, okay, you've questioned the following 5 doctors and 2 nurses. The case should have been over at that point. And realistically, in my opinion, he's right. It should have been. But the defense had a different opinion. So when he called me to say, I'm not getting any younger, it's because he was frustrated with the pace at which his case was not yet resolved. And this is the problem with the legal system. The problem is that there are so many inherent delays associated with conducting discovery, the exchange of necessary documents, with the pace of getting depositions completed, with the pace of getting these cases evaluated, with the evaluation now coming to the decision about whether or not they are or are not going to try and negotiate. Now, I will share something else with you. Even if the defense had come to the conclusion that this case was worthy of trying to negotiate before trial, it does not mean, and it certainly does not guarantee, that your case would be settled at that stage before going to trial. Why is that? Because the defense always has a different perception about the true value of your injuries. So imagine this. We are all working on the same page. We all know what your injuries are. We all know what your limitations are. We know what disabilities you have. The question is, if we all know the same exact information, why is it that the defense believes that the value of your injuries are so much less than what we perceive the value of your injuries to be? And now you have a clear dispute between the value of these injuries. So even if they tell us, listen, we think this case should be settled, let's go ahead and have a settlement conversation, or maybe let's go ahead and enter into mediation, which is like a settlement conference using an impartial person to help us facilitate, to try and move settlement discussions along. In that instance, now there's a clear dispute between what we think your case is worth and what the defense thinks your case is worth. And the goal of this settlement discussion or this mediation is to try and reach an agreement where each side believes that they have reached the correct number. So getting back to the comment that my client raised that I told you about at the beginning of this video, I'm not getting any younger. I responded, yes, I realize that. And if there is something else that I could do to expedite your case, I certainly would, because I don't want this to go on a minute longer than it has to. And the only way we can go ahead and use the leverage of the facts of this case in our favor is to clearly show to the defense that we are in a much better position than they are, and it would be well worth their time and investment of resources to try and resolve this case now rather than going to trial. So why do I share this quick information with you? I share it with you because this comes up often where a client calls me up, they're all frustrated, they don't understand what's taking so long, and now I begin to explain, just as I've done today's video, all the different steps that have to occur for the defense to begin to recognize that, hey, they've got a problem, and now it's time to start talking. You know, I realize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York, and you have not yet started a lawsuit, but are thinking of doing so, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.